Hi, everybody. Thanks for joining and welcome to my lecture, How Courts Translate Equality into Law. And so in this episode, obviously, this is going to be a natural extension of Lecture 1, which we discussed textualism, originalism, and living constitutionalism. And we're going to transition from judicial method in the abstract to equality doctrine as a site where word choice framing and legal tests can quietly move outcomes. So let's go ahead and get started. So in this episode, or this lecture, here's our following roadmap. As you can see on the screen, we're going to start with the text to the doctrine. Let me see if I can adjust my screen for you. We're going to begin with the Equal Protection Clause itself and the translation problem. Broad constitutional language must become administrable legal standards. Equality models. We're going to trace anti-classification, anti-subordination of tiers, anti-subordination, tiers of scrutiny, and the case spine of everything from Brown v. Board of Education through Students for Fair Admissions. And then we're going to go through some different language conflicts as well when we're dealing with notions of equal protection. So let's go ahead and move on. So we have a translation problem. Let's see if we can actually get everything on screen. Here we go. So topics covered. Let me put it up for you. In this, we're going to go over, the Equal Protection Clause and its interdeterminacy. Who is protected from what and why the text does not itself specify the doctrinal machinery. We're going to do the translation problem, how judges turn equal protection into tests, classifications, burdens, and evidentiary requirements. We're going to go over competing equality instincts, anti-classification, and anti-subordination as rival lenses for reading the same constitutional promise. We're going to go over strict scrutiny framework, which is the compelling interest, narrow tailoring, alternatives, duration, and proof required by the Constitution. We're going to quickly go through the case spine, which led to the doctrinal development of all of these, legal notions, which involve Brown, Bakke, Croson, Grutter, and SFFA as a changing story about race-conscious state action. And then we're going to quickly touch on linguistic gamesmanship, because obviously that's more my focus, is focusing on how judges and lawyers and, more in general, people can manipulate language to advance their own political or legal causes. So we have to transition from words to doctrine. Lecture 1 asked how judges claim to read legal language faithfully. And so in this lecture, we're going to ask what happens when the operative constitutional word is equality itself. So the Equal Protection Clause, this is the most fundamental of all clauses when we're dealing with notions of equality within American law. No state shall deny to any person within its jurisdiction the equal protection of the laws. So what the text gives, this is very important for textualists: a state actor, a protected class of persons, and a guarantee of equal protection. What the text leaves open: equality of what? We don't have, what is equality according to this? Against which classifications? We don't understand what classifications we're dealing with according to just this text. Under what evidentiary standards and what judicial test? And these are going to be different notions that we're going to break down. But a key teaching point here is to implant in your mind what the Equal Protection Clause, the EPC, states right here, which is no state shall deny to any person within its jurisdiction the equal protections of the laws. This is what prohibits a state from, unequal treatment of persons within its jurisdiction, and it also applies to the federal government through the Fifth Amendment. So why does equal protection need translation? Well, judicial necessity. Courts cannot decide cases by invoking equality at a high level of abstraction. They need criteria that can be administered, reviewed, and repeated. And then also methodological continuity. This is lecture 1 in more concrete form. So if you haven't seen lecture 1, go back a video for how judges read the Constitution, and it'll make a little bit more sense. But this moves from constitutional language to doctrine, which always requires framing choices. And those choices can be disciplined or manipulative. And that's what I like to discover in my own legal exercises. When are judges being manipulative versus when are they being disciplined? The translation asks, equal with respect to what? for whom, and against which forms of governmental decision making. So we have two equality instincts, as you can see on screen. We have anti-classification, which means the state presumptively violates equality when it sorts persons by race or similar protected status categories. The core wrong is classification itself, meaning any type of classification that is on the basis of a protected category, such as race, just classifying itself is wrong. And that's where I believe a lot more of our conservative jurists and judges think in this frame of mind. They do not want to classify whatsoever because, again, classification itself is the wrong for purposes of equal protection. That's the theory. On the other hand, we also have the anti-subordination theory, which is the state violates equality when it entrenches or legitimates group hierarchy. The core wrong is in the maintenance of structures of domination. Both approaches speak in the language of equality, but they do different doctrinal work and often point toward different outcomes. And so what we really need to understand when we're breaking that down is when we're dealing with, again, anti-classification, that means the classification itself is wrong. Anti-subordination recognizes that, hey, we actually do have hierarchies on, different identity groups. So maybe an ethnic hierarchy or a racial hierarchy at a social level. And there are some judges that say, look, we're going to take in evidence to recognize this hierarchical evidence, and then we're going to address it. So by virtue of, creating a hierarchy, it's necessary to classify people. And so you can see where anti-classification and anti-subordination are somewhat really in direct conflict with each other. One classifies, the other doesn't classify, and both are striving for equality. And so that's what makes, this, legal debate unique. Moving on to the next slide, how doctrine stabilizes meaning. Once equality is translated into doctrine, the legal system acts as if its key terms are stable, even when their social meaning remains contested. And so we're going to go through a little bit of that more throughout this slide. But first, we have to discuss strict scrutiny as the dominant race framework. So whenever we see, race come up in law, you always must think strict scrutiny, and that's what we're going to jump into. So as you can see here at the bottom, the trigger for strict scrutiny is facial racial classifications by the state normally trigger strict scrutiny automatically. And so that means if the government ever even writes something that has to do with race or ethnicity into the law, strict scrutiny is going to be triggered. So if the legislature, your own state legislature, Congress, you name it, if they suddenly start classifying, hey, Black Americans, white Americans, Asian Americans, Latino Americans, you name it, strict scrutiny is going to be triggered just by virtue of classifying ethnic or racial groups. So it's a very important point to know. And then we got to jump into the demand. The government must identify a compelling interest and prove narrow tailoring. And what that means is this, is the government at the legislature, whether it's the state level, the federal level, and they decide to create a racial or an ethnic classification or any type of protected classification. What is the compelling government interest? And what that means is, why are you doing this? Like, what's the interest in you creating a law that implicates race or ethnicity? Because generally you could probably pass laws that don't require these types of classification. So if you're going to do it, we need a compelling government interest as to why. And also, if you're going to do it, the law that you then use or you enact in order to enforce this compelling government interest must be narrowly tailored. And again, narrowly tailored just means, like, let's say you pass a law that, seeks to remedy, because obviously to remedy, you're going to have to classify groups, right? And you're seeking to remedy historical discrimination against, let's say, Black Americans. Okay, well, whatever law you take to implement remedying that historical discrimination, it must be narrowly tailored. It must make sense. Imagine you passed a law and it said all of this about, we're going to remedy all this historical discrimination, and then suddenly you've got police officers out in the streets stopping white Americans in cars, you know what I mean, to say, hey, show me this. And it's like, I mean, that's not happening today. But what I'm doing is illustrating a point where it's like, okay, we're stating we're trying to advance this government or compelling government interest, but why are we doing this in order to advance that compelling government interest? And when we're dealing with narrow tailoring, it must be narrow. Like this must very much advance that law. It can't be, oh, it kind of does. No, it is directly advancing that law. So very important to know. What's the practical effect? Modern doctrine puts anti-classification at the center, even while anti-subordination arguments remain in the background. And so what that means is modern U.S. doctrine more so pushes anti-classification rather than anti-subordination. And we're going to jump into why that is the case. So again, we kind of already went over some of this. What does strict scrutiny actually ask? First, we need a compelling government interest. Is the state pursuing an interest of the highest constitutional order? And then we need to evaluate the fit. Do the means track the objective closely rather than broadly or mechanically? Then we have to evaluate alternatives. Has the government seriously considered workable race-neutral tools? And then we have to go to the endpoint. Is the policy bounded, reviewable, and limited rather than indefinite? Okay, now moving on to proof burdens. We have to evaluate evidence, duration, and doctrinal discipline. So we have to give an evidence-demanding review. Courts ask for specific proof of the problem being addressed and of the efficacy of the chosen remedy, not just generalized appeals to fairness or history. And so what this means is if you're going to go to court and you're going to claim, this type of, discrimination and lack of equality, you have to have hard evidence, not just a social narrative, but hard evidence of this discrimination. And then we also have temporal limits that arise when we're dealing with different laws, such as sunsets, review mechanism, and defined stopping rules signal that race-conscious tools are being treated as limited means rather than permanent forms of governments. So let's move on. So we got to go through the case spine of equality doctrine. And so we're going to go through these central cases, which are not just holdings. They are shifts in how courts define injury, neutrality, and permissible remedies. So we have to go through Brown v. Board of Education through SFFA. And just to be clear, there are many more cases which have developed on the equal protection principles in American law than just what you see on screen. These are just some that we're going to discuss for purposes of this lecture. So obviously here at the top, we have the very famous case Brown v. Board of Education. It held that segregation is inherently unequal. The opinion attends to status, stigma, and the social meaning of enforced separation. And again, Brown v. Board of Education simply developed as a result of the segregation of schools for children. And after this decision, it led to the integration ethnically and racially of U.S. schools across the nation. Then we have Regents v. Bakke, which is a case in 1978. I believe this was at UC Davis, and what had occurred was the medical school there had basically said, look, we accept people all equal. However, we're going to reserve a specific quota for minority students. And in Regents v. Bakke, this went all the way up to the United States Supreme Court, that they held that rigid quotas are rejected, but diversity emerges as a potentially permissible educational objective. And so what the court did is they tried to thread the loop and do two things at once. They tried to say, look, we recognize that diversity is a permissible educational objective. If a university says, hey, we want a diverse campus on this basis, they'll recognize that as a compelling government interest and a legitimate government interest. However, in order to advance that interest, you cannot place quotas and rigid racial quotas, ethnic quotas, in order to advance that. And so that's what Regents v. Bakke held, and that does get developed throughout time. And so then we got City of Richmond v. Croson, which is a 1989 case, and it held that generalized societal discrimination is not enough. Remedial race-conscious action must track the government's actors' own identified wrong. And so what this case was about, in City of Richmond v. Croson, the city of Richmond was a majority black city, and it had passed a law that said they gave out public contracts. And a public contract is just the government gives out a contract for whether it's goods or labor, you name it. And when they were giving out contracts, the government, they said, we want a certain percentage to be ethnically based. And we went all the way up to the Supreme Court, and they said, no, you cannot be, factoring in certain percentages of your public contracts going to certain ethnic groups, especially without hard evidence. Because in this case, the ones who represented the city argued that, hey, there's been historical discrimination, and they came into court with more of a societal narrative. They didn't come in with hard evidence, and ultimately, as a result, the court rejected it. And so then, moving on to Grutter v. Bollinger, a case in 2003. This held that holistic review survives because diversity is tied to individualized consideration, flexibility, and the idea of an eventual endpoint. And if I'm not mistaken, this was the University of Michigan case where there had been basically reverse discrimination, and a white student had sued. And the university had held that racial consideration was proper for purposes of admitting the student, and the student challenged. We could probably dive into more details, but let's go ahead and move on for here. So we also have Students for Fair Admissions, which is a 2023 case, and it held that race-conscious admissions are recast as insufficiently measurable, insufficiently bounded, and too inconsistent with individual treatment. And so again, you see a lot of these cases developing in the context of public education, because public education is a service offered by the government, and there's typically only a limited number of spots available. And if the government is going to restrict access to public education, especially higher public education at universities, it cannot do so we're going to target race and make quotas and things of that nature. So this is some of the doctrinal spine. We could go in and have multiple cases just on these cases and evaluate them. However, we have to quickly continue and start discussing more at a general level some of the linguistic flaws that come with equal protection doctrine, which also somewhat arise from these cases. Here we go. So segregation as inequality, not just classification. So the doctrinal lesson comes from Brown v. Board of Education, which Brown is hard to explain as mere formal symmetry. It treats separation itself as expressive of inferiority. And so what happened is in 1896, 1898, the Plessy v. Ferguson decision upheld separate but equal. However, after almost 60 years of that precedent, 50 years of that precedent, 60 years of that precedent, the Supreme Court said no. Separate but unequal, or separate but equal, automatically creates separate but unequal. And so they purely rejected Plessy v. Ferguson, and Brown v. Board of Education overruled precedent. What's the methodological lesson? The opinion resonates with anti-subordination because it attends to the social meaning and structural consequences of state action. And so what that means is this. We discussed earlier the anti-classification and the anti-subordination theories of advancing equality. Anti-classification, again, held that classification itself is inherently wrong and violates equal protection. However, when we read a decision like Brown v. Board of Education, it inherently more or less tends itself to anti-subordination. It recognized a racial hierarchy, ethnic hierarchy. It recognized classifications, and it remedied them by ordering integration of American schools, and held that Plessy v. Ferguson actually did not fit the Constitution, and minority school children, minority in the context of historical oppression and numerical, which we'll get into, that was improper. But let's go ahead and move on. So diversity as a carefully cabined rationale. So again, as we discussed, we have no quotas. So rigid set-asides look too blunt and too detached from individualized review. We also have some flexibility. Race or ethnicity may be one factor when embedded in holistic judgment rather than mechanical assignment. And so again, you can consider race or ethnicity, but it cannot be the dispositive outcome. So you can't say you're admitted to the university program on the basis of your race or ethnicity. You can consider it, but it's not dispositive. And also we have some built-in fragility. The more doctrine demands metrics, endpoints, and neutrality, the harder it becomes to sustain race-conscious policies over time. So, how remedial and diversity arguments narrow. And so here's Croson's move. So we discussed Croson, which was the city of Richmond case. Remedy must be tied to a specific identified governmental injury rather than to broad history or generalized social hierarchy. And so again, if you're going to go into court and and try to defend laws which are pretty much favoring minority ethnic or racial groups, you can't just go in with broad history or societal narratives. You better go in with hard evidence, and that's what Croson requires. And then also the student SFFA's move is diversity becomes vulnerable when courts insist on measurable objectives, bounded duration, and skepticism toward any use of race that looks systemic rather than individualized. So the doctrine is clear. Equality increasingly means distrust of explicit classification, even where proponents describe classification as a temporal tool against entrenched inequality. So again, always coming back to this anti-classification, anti-subordination, competing theories of advancing equality. So now we're moving into something I really enjoy when we're talking about these ideas: linguistics and equality gamesmanship. This is the bridge from Lecture 1's language analysis to equal protection. Constitutional disputes often turn on what loaded words are allowed to mean. And so now let's dive into how one can use language and linguistics to advance their own political or legal interests or viewpoints. Well, here's one of the things we're going to have to discuss. So we're dealing with remedial measures, right? And remedial measures measures to remedy something. And so what that means in constitutional law is, let's say we have a historically discriminated against minority, let's say Black Americans. There can be a societal narrative that entrenches this narrative that they will always be oppressed. They will always be minorities in the nation. And that creates some long-term and short-term problems, actually, when we're talking about notions of equality. One of the issues, though, is there is categorical rigidity, as we discussed. And what that means is this. Okay, what if a historical minority group one day became the majority group? Would they still be considered, to have this oppressed minority narrative, or should they, now that they're numerical majorities, be considered more of the majority, not a minority? And we're going to jump a little bit more into that, but this is just introducing how categorical rigidity arises in this context and how social narratives can cause some of this categorical rigidity, and we need to advance socially at times. So here's the problem. Equal protection doctrine can become categorically rigid when legal actors force changing social conditions into fixed classifications and inherited narratives that no longer fully describe how hierarchy operates in practice. Here's the risk. Jurists may cling to familiar stories about who counts as disadvantage, what counts as discrimination, and what counts as a real remedy, even when the social world has shifted underneath those categories. That rigidity is not only conceptual, it can drive legal outcomes by making some facts legible to doctrine and rendering newer forms of inequality almost invisible. And so, let's go ahead and advance to the next slide. If you have any questions about that, please leave it in the comments. But again, just to quickly summarize that up, it's simply where people in our society, including judges, do not let go of past narratives related to minorities. And when those narratives evolve and maybe not minorities then become majorities, do those jurists and do those people change? Sometimes you actually find they don't. They want to cling to old narratives. So why does Croson matter in this context? So here's the doctrinal contribution of Croson, which we've already discussed Croson. That was the city of Richmond case, handing out public contracts on the basis of ethnicity. Croson rejected generalized assertions of societal discrimination as a sufficient basis for rigid race-based set-asides and insisted on a tighter evidentiary showing tied to the government actor's own identified wrong. And so what that means, again, as we've discussed multiple times already, you're going to go into court, you can't just go in with societal narratives. You have to go in with hard evidence of historical discrimination. Here's the constraining virtue. That insistence can be defended as a real discipline on broad social narratives. Courts should not constitutionalize sweeping historical stories without proof, fit, and administrable limits. Here's the enduring tension of Croson. But the same demand for tight categories can also underread changing forms of exclusion by forcing dynamic social patterns into older doctrinal boxes that the law already knows how to process. So that's a lot of legal jargon, but ultimately, let's not be categorically rigid. Let's not let social narratives cause us to be categorically rigid. So how equality language becomes argumentative leverage. So we can have victim reassignment, which is to frame a race-conscious policy as discrimination against current applicants rather than as a response to inherited exclusion. We have neutrality inflation, which is treat facial neutrality as morally sufficient even when the policy predictively preserves an existing hierarchy. And then we have remedy contraction, which is to define legitimate remedy so narrowly that only the most specifically documented wrongs qualify, leaving structural inequality outside doctrine. So this is one of the points that I was really wanting to make in this video, which is the term minority is not one idea. And you'll see this come up a lot. And I'm going to show us some videos on how the term minority can be used in invisible multiple ways. And I identify two main ways that the term minority is used. And depending on the politics of the person, that this is how they can advance it. So first, we have a numerical meaning, which is a numerical meaning for minority is this. A minority can mean a group that is smaller in raw numbers, underrepresented in a school, workplace, electorate, or district. And so what does that mean? Okay, well, let's say we have a town, right? And it's got two ethnicities, ethnicity A and ethnicity B. Ethnicity A makes up 70% of this town. Ethnicity B makes up 30% of the town. Okay, well, ethnicity A is the majority and ethnicity B is the minority, right? That's just the understanding numerically of the term majority and minority. So pretty simple, correct? We also have what's a historical subordination meaning. And what this means is a minority can also mean a group marked by long-standing stigma, exclusion, political vulnerability, or caste-like treatment, even where raw population figures alone do not do the work. The argumentative move matters. Once minority is defined numerically, history can disappear. Once it is defined structurally, formal headcounts lose explanatory force. And again, historical subordination meaning of the term minority just means, is this person that belongs to this group, have they been historically disadvantaged? And one of the ways you hear about this, generally in social narratives within American law, is that, let's say, Black Americans have been historical minorities within our country. And so they've met both meanings, right? They've always been, well, depending on the state. South Carolina, I believe at the time of the Civil War, was actually majority Black, not majority white, numerically speaking. But obviously historical subordination, if we're counting that, they would be the minority in this context. So you can see how minority and majority can be somewhat slippery and you don't know how to hang on to it. But I just want to quickly show you guys some videos on different politicians and legal jurists using the term minority and majority in this dual way. And sometimes it's difficult to crack how they're using it or what they actually believe. So first things first, let's go ahead and show this presentation.
Our friend Jason Riley published a column in the Wall Street Journal headline, according to NBC News, since 2012, there has been a 15-point shift toward Republicans among Black voters, a 32-point shift among Asians, and a 38-point shift among Latinos, close quote. Donald Trump, of all people, is the one who has demonstrated that we can move beyond identity politics, that African-American males move toward the Republican side. Now, you can like the Republicans or you can dislike the Republicans, but the argument would be people are making up their minds for themselves as individuals, not simply voting on the basis of their race.
Yes, and it's one of the most encouraging developments, and one I was surprised to see come finally. One of the reasons, for example, why it's so hard to get a decent education for Black kids and low-income Black kids is that the black vote has gone automatically to the Democrats by huge margins for a very long time. And it's the Democrats who get the money from the teachers union, for which they will then allow the teachers union to do whatever they want, regardless of whether that is bad news for the black kids who can't get a decent education. However, Jason Riley writes for the Wall Street Journal, which is an excellent publication. But unfortunately, low-income people are not likely to be reading the Wall Street Journal. And I don't know if there are enough people within the black community, leaders, who have a sufficient interest in making clear what these alternative educational things are like, that the civil rights organizations have lined up with the teachers union. And I think, quite frankly, they're doing it for the same reason that the politicians do it. They get money from them. I can remember decades ago, a black Democrat that I knew said that NAACP has become a wholly owned subsidiary of the labor unions. He didn't say that publicly, but he said to me privately. And unfortunately, that's not uncommon.
It is the white liberals.
Whoops. Okay, so what we can gather from that is this. First things first, let's go ahead and address the elephant in the room. It's a little bit hypocritical to say President Trump and his supporters overcame identity politics, and the very first thing you do is cite literally a bunch of identifiable minority groups, right? Does anybody follow me on that? I mean, you can't overcome identity politics and then cite evidence of identity politics. And it's inherently in conflict with each other, and sometimes you get this circular type reasoning. But yeah, the way I would say the definition was used there is we had the term minority describing what I think is more of a numerical minority because, the identity politics. However, Thomas Sowell, he's a very famous black conservative activist for many decades now. He'll probably go down as one of the most famous, actually. But he tends to have a dual meaning as well. He can use it in the context of a numerical minority. He can use it in the context of a historically marginalized minority. And so sometimes it's difficult to know. I got the connotation he used it in the numerical sense. However, maybe he didn't. Maybe he meant it completely in the historical marginalization context. So here is Condoleezza Rice. She is also a historically famous black politician within the United States, and you can see how she uses the term minority here.
So are you for school choice or not? We already have a choice system.
Whoops.
In education. If you are of means, you will move to a district where the schools are good and the houses are expensive, like Palo Alto, California. If you're really wealthy, you will send your kids to private schools. So who's stuck in failing neighborhood schools? Poor kids. A lot of them minority kids. So how can you say you're for civil rights? How can you say you're for the poor when you're condemning those children to not being able to read? By the time they're in third grade, they're never going to read. So if you want to say that school choice and vouchers and charter schools are destroying the public schools, fine. You write that editorial in the Washington Post, but then don't send your kids to Sidwell Friends.
Given the fact that I'm pretty sure you're.
All right. And so what you saw there was Condoleezza Rice. The way she described minority is she described them more as poor kids. So I didn't know if she meant minorities and ethnic minorities or racial minorities. She wasn't very clear. The way I gathered was maybe she has a more Marxist or like left-wing type of framing where minority just means poor and marginalized in that sense. So I find Condoleezza Rice framing of that interesting. She somewhat hints that there is an element of racial or ethnic, component to it. However, it's simply not clear, and we can't definitively make that the framing. Maybe she meant, poor white kids, right? It's difficult to tell just on that. But I'm just going to say she was being a Marxist there and describing poor and minority as the same. So let's go ahead and show the next video that we got.
This is central to whether or not we maintain a multiracial democracy in this country and a real way for Black people, for Latinos, for Native Americans.
And just for context, this was about a recent Supreme Court decision that more left-wing people did not agree with. Here, as you can see, Ms. Wiley is a civil rights attorney, and a lot of civil rights attorneys are, their reputation is that they're very left-wing and activist and things of that nature. But I just want you to see how she describes minorities, and it's more so historically marginalized. But also, there is the element of numerical minority status as well. However, we are also living at a time of changing demographics within the United States. And I believe that actually people under the age of 18 I think whites are actually not the majority. So to call, what are they? Are they the minority? Are they the numerical minority? Do these groups that she describes also get to maintain the historically marginalized minority status while also being the numerical majority? And so how do we see that? But let's go ahead and watch the rest of this video.
Americans and Asian Americans to have a real opportunity to say who leads us. It is that simple. What Justice Alito and this really radicalized right-wing majority did was say, because we think that we shouldn't be able to say anything about partisan politics, we're not just going to create a loophole. We're going to create the sunken place where essentially any politicians who are controlling the politics of the state can just say, we're not discriminating. We just want to win. And we will win if Black people can't have a district where they have the ability to say who leads them. Because rather than competing for our votes, rather than trying to find the kinds of coalitions of the willing to create and create solutions to problems we all share, they'd rather just figure out a way to stay in power.
So again, basically, we can't tell whether she means minorities in the context of numerical minorities or historically marginalized minorities. I got the sense it could be both in that situation, quite frankly. And then also, I would like to show this lawyer as well. And he kind of gives an overview of the recent case and how he's also going to legitimize the anti-classification doctrine itself. So earlier we discussed anti-classification and anti-subordination. Anti-classification says that classification itself is wrong. Anti-subordination theory of equality recognizes that classifications are necessary in order to remedy historical discrimination. And so let's see what this lawyer has to say.
Several reasons why this matters. So this hand down by the Supreme Court is a really big deal for anyone who's part of a quote unquote majority group, i.e. if you're heterosexual, male or white, because now in the workplace, you cannot be discriminated against just because of the group that you're a part of, and you don't have a higher burden of proof to prove that discrimination. In other words, if you're white and you get passed over for a job by a Black person who is clearly not as good as you, you can say that's discrimination, and it's not people looking at you like funny because, well, you're white. How can you claim discrimination? Same way a Black person can. That's what this case is saying. That now everybody's got to be treated equal in the workplace. This matters as well because, again, I just told you precedent. When a precedent is set, if this applies in the workplace, it can apply at home as well. It can apply in the neighborhood as well. Doesn't mean it's always going to cross over perfectly, but it sets a precedent that you can't do this and discriminate based on color. Well, why can't that apply somewhere else? And the answer is, well, there is no answer. It can apply somewhere else. That's why this is a big deal. This affirms that civil rights protect individuals, not just historically marginalized groups. That's what this says. That's what civil rights is supposed to mean. Several reasons why this matters. So
as you can see, that attorney himself also endorsed the anti-classification theory of equality as the current trend within American law, even though we have seen in cases of the past anti-subordination theories of equality show up. And it just depends, as more of our conservative-minded justices tend to lean towards the anti-classification theory, while our more liberal-minded justices tend to lean towards the anti-subordination theory. And again, just to point out, as we had on screen, very important, it is not always clear whether the term minority as it's being used is being used as in a numerical minority or historically marginalized minority. So let's move on to the next one. This is linguistic manipulation in constitutional form. The same moves discussed in Lecture 1 reappear here. There are generality shifts, category selection, context reframing, and strategic claims of neutrality. The judge or litigant can say, I am only applying equal protection, while quietly deciding what counts as discrimination, who counts as injured, and which baselines are natural. The critical questions remain the same. Why this definition? Why this baseline? And why call this usage neutral rather than contestable? So again, each side, both our conservative justices and our liberal justices, they can somewhat say, hey, I'm applying equal protection. However, both have their own mental models and frameworks for advancing equality. So let's go through a quick thought exercise just to give us a little bit of, a sample. And I want everybody that's watching this video up to this point to give me your thoughts, maybe. So let me put it on our screen for us. All right. So thought exercise, universal words, competing methods. A quick classroom prompt can connect equal protection to the Lecture 1 conflict between universal textual language, originalist history, and precedent. Let's move forward. How do judges handle universal language? Well, first we have a liberal tendency. And a liberal tendency is a justice with a more expansive equality orientation may stress the universal phrasing of the 14th Amendment and ask why the broad text should not extend to newly recognized groups, including LGBTQ claimants, once precedent and social understanding have developed. And again, we go back to the equal protection clause that we discussed earlier, and that I showed that, any person has the right to equal protection of the laws within any state by both the state government and the federal government. And generally, since the 14th Amendment, it reads as a universal text. Like it seems like it could apply to any group, right? When you just look at the text. Liberal justices have a tendency to say, well, look how universal that is. We must apply it at its universal level. Now, conservative justices are not always on board with that framing. And so let's give the conservative tendency. The conservative tendency is a justice with a stronger originalist in orientation may answer that broad words must still be read through the original public meaning, historical legal categories, and long-standing limits understood at ratification, rather than through present-day moral expansion alone. And so what that means is this. Where liberal justices have the tendency to say, look how broad and universal the 14th Amendment is. It applies to everybody. Why doesn't it apply here? And let's say just this new LGBTQ group. Conservative justices will respond, look, we recognize it's very universal in that framing. However, at the time, this is what the authors of that universal language meant. They didn't mean this group. They didn't mean this new LGBTQ group. And so that's how conservative justices argue it. Liberal justices could respond in kind and say, well, all right, Mr. Conservative Justice, well, why didn't the, framers or the ones that authored the law, why didn't they write what you just said? I mean, you clearly seem to think you know what they meant, but why didn't they include that in the law? Why did they choose these specific words to convey what they wanted as law? And that's really the conflict we have between conservative and liberal justices, especially with these universal texts like the 14th Amendment. So, as you can see here at the bottom, to an outside observer, aggressive restoration can look like a conservative version of living constitutionalism in reverse, not updating text to modern values, but updating doctrine by reopening settled precedent in the name of recovering lost original meaning. And so what we mean by that is conservatives will generally critique liberals, justices, as being more, hey, you have living constitutionalism. You don't want to understand the text and how the text was applied with its original meaning. However, let's say we discussed earlier with the case Wong Kim, or in my lecture 1, we looked at the case Wong Kim Ark, which gave birthright citizenship, correct? Well, that case sets precedent in 1898. And so for over 120 years within American law, that has been the precedent. However, we currently have conservative political and legal movements that have developed within the United States that have now questioned Wong Kim Ark and that settled precedent. And they do it under the banner of advancing originalist intent. And this is best conveyed by analyzing how President Trump has said the 14th Amendment and that the 14th Amendment with respect to, all persons born within the United States, that language applies to the babies and, of slaves and slaves themselves, because slaves were born in the United States at that time too. So that applies to slaves and their children. However, that's taking, you're trying to advance, President Trump and all of his political and legal followers in this context are trying to upset historical precedent to say, look, we understand there's been over 120 years of this precedent. However, it's been applied wrong for over 120 years. Here's the original meaning. And that really looks like living constitutionalism from the conservative way. So we have the liberal way of living constitutionalism, and here's where how conservatives themselves can use it. So, how might an originalist overcome the apparent universality as we discussed? So, as we can see on screen, we have the semantic level. Argue that universal words like person or equal protection are broad at the surface, but still take legally fixed content from the public meaning they had when enacted. We have the historical level. Argue that the ratifying generation did not understand the clause to forbid every modern category distinction. So current extensions require justification beyond bare textual breadth. And then we have the precedent level, which is argue that some precedents departed from original meaning and that restoring the clause's historical content is correction, not judicial innovation, even if it disturbs settled expectations. And as we saw in Lecture 1, generally, most of our originalist judges who are, tend to be conservative justices, but I also think liberal justices can be originalist as well. They will have a tendency to upend precedent whenever they feel like there's been a historical wrong that was decided by the court. And Justice Amy Coney Barrett said when she felt a case was egregiously wrong. And so, again, it can be a bit vague when to decide cases were egregiously wrong, especially if those cases have been within precedent for even over 100 years, right? Like, you got to respect that until you don't. So that's just the development of law. Let's move on to the next slide. So, questions for the room. Whoops, let me pop those back on for you. When do universal words outrun original expectations? Should broad constitutional text control even where ratifiers would not have anticipated the present application? When does restoration become revision? At what point does overruling entrenched doctrine in the name of history start to resemble the living constitutionalism conservatives criticize? And finally, what should students watch for? So, students meaning just the audience. Definition choice, baseline selection, precedent handling, and whether appeals to universality or history are being used consistently across cases. And so, getting really effectively to the thesis of Lecture 2, equal protection doctrine depends on terms whose social and political meaning is unstable. That instability is where linguistic gamesmanship enters. And then we have unstable words and stable tests. So we have a doctrinal aspiration, which is courts act as though terms like discrimination, neutrality, diversity, minority, and remedy are stable enough to function as inputs into legal tests. And then we also have a doctrinal risk, which is when those same terms drift into politics and culture, the tests built on them become unstable, contested, and vulnerable to strategic use. And so, for our central takeaway, Lecture 1 showed how judges can manipulate meaning through framing choices, and Lecture 2 here shows that equal protection is one of the richest sites for that manipulation because its operative vocabulary is morally charged, socially contested, and doctrinally decisive. The larger lesson is that equality doctrine does not eliminate interpretive struggle. It organizes that struggle through words that remain open to strategic redefinition. And again, I believe it's ultimately my theory that conservatives and liberals engage in this form of linguistic manipulation. I think each side says that they're advancing originalism when it's convenient, and then each side says they're advancing textualism when it's inconvenient. So effectively, judges on the liberal and conservative side both see themselves as textualists and originalists. What occurs is when then there are disagreements within textualism and originalism as applied, maybe on the internal political framework of the judge or values framework. It emerges with each side pointing fingers at each other that they're engaging in living constitutionalism. And, as we discussed in this lecture, I think one of the most interesting aspects is how the term minority can be manipulated to mean Are we dealing with a numerical minority, or are we dealing with a historically marginalized minority? And obviously, if we're dealing with numerical minorities or historically marginalized minorities, can those groups change? So let's say we're in the year 1 of this new country, right? But we're in America law, so we have to think America. But let's say 200 years right now in America, let's say there are new ethnic and racial groups that dominate American society, or religious groups, you name it. We can go down any types of groups. How should the law apply to them? Should they still be considered historically marginalized minorities if there's been a long evidence? You always have to present hard evidence of discrimination, maybe even hard evidence of majority status. So you can't just rely on social narratives. How should judges factor that in? How can judges, or even people in the general public, know when certain ethnic or racial groups or religious groups are no longer the numerical minority or the historically marginalized minority? Are conservatives or liberals, are they too static? They don't want to change. Conservatives want to see this religious group, for example, as discriminated against, and this one is having privilege, while liberal groups always want to see this ethnic group, this racial group is always having privilege, and this one as not having privilege. And will they ever, depart from those understandings? Will those same justices, conservative or liberal, ever see these individuals within these groups as altering? Now you become the numerical majority. Now you're no longer historically marginalized. You're actually historically favored. And so that would be a very interesting analysis to go down. But obviously that only happens with time, and it doesn't happen usually in a day. It doesn't usually happen in a year, maybe not even a decade, maybe not even a generation. Maybe it may take 100 years. So that's really all we got for this lecture. If you have any questions, please leave them in the comments. I would love to read them. I find equal protection law and the context of the linguistic application such a fascinating concept. I hope you did too. And please like and subscribe. I would very much appreciate that, and share this video with somebody that you think would find it interesting. So thank you very much.